PITS Sambalpur Shorthand Dictation. Speed 80 words per minute. Dictation starts in 5 seconds. Learned Council compared the terms of the previous policy bracket open, which had covered the period March 2007 bracket close, with the policy in question and submitted that the overall limit of coverage was changed by the appellants as compared to the previous year. Stop. It was also stated that the previous policy covered health risks of three individuals, that is, the appellants and their son, whereas the policy in question covered only the appellants. Stop. Counsel submitted furthermore that the insurer had undeniably issued a notice pursuant to which a policy was renewed on 26/3/2008. In the circumstances, it was duty of the insurer to inform the insured of the likely change in coverage to enable them to explore an alternative, that is, to opt for a policy that would cover all risks more comprehensively, even if it were to cost them more. Stop. Counsel urged that in these circumstances, the insurer was clearly guilty of deficiency of service in as much as the insurer was in the dark about the nature of the limited coverage. Stop and para. Learned counsel on behalf of the insurer, Mr. Amit Kumar, urged this court to uphold the finding of the NCDRC, submitting that there was no deficiency in service by the respondents. Stop. It was submitted that the appellants never disputed that, in fact, the policy was dispatched pursuant to the renewal. Stop. A careful reading of the policy for the year 2008 to 2009 would have indicated that it differed radically from the policy from the previous year because of a term indicating a monetary limit on the reimbursable expenditure, by the insurer. Stop. In these circumstances, the appellants could not place any blame upon the insurer. Stop. It was submitted that the insurer was under no obligation to indicate or to intimidate to the appellants about the likely changes under its policies. Stop. In other words, there was no duty in law which obliged the insurer to intimate the policy holder at the point of time of renewal that the terms of the new policy would be different from those of the earlier, lapsed/expired policy. Stop. It was submitted that the term renewal has no special significance given that the contract of insurance, that is, policy in his case, is the first annual one. Stop. Therefore, the policy for 2008 to 2009 is a different contract of insurance from the one which preceded it. Stop. Learned counsel submitted that the very circumstances that a higher coverage limit was indicated in respect of two individuals only as compared to three insured under the previous policy showed that the insurer had complied with the offer of the insured, who desired such coverage. Stop and over. This dictation was presented by PITS Sambalpur. Keep practicing.